All right, so did the FBI Director James Comey do the right thing? Here now is Donald Iyer, former U.S. Deputy Attorney General. You were part of the group that signed a letter saying that you didn't think that they did the right thing. He did the right thing here. You call it Comey's mistaken quest for transparency. How so?
Well, in our system of prosecution, there's an unwritten but very widely understood rule that prosecutors and investigators investigate, gather evidence, and they decide if they have a case that they can prove beyond a reasonable doubt, and if so, they'll take it to the grand jury and bring charges. And the other part of the rule that's really very important to all of our rights is that if they aren't ready to prove a case, the answer is we are not going to file any charges, and the prosecutor then closes his or her mouth.
Okay.
That is the uniform practice. Okay.
Yeah,
and that's not what happened here back in July.
Without question. But when you go back and you look at James Comey's testimony when he was taken before Congress, and he was asked directly, what happens if you find new and compelling evidence in this case? Will you reopen it? Will you let us know? He said yes. I mean, they've played back the tape. It seemed like if he didn't do that, he would face charges himself, since he had sworn under oath that if he found new evidence, he would immediately alert Congress.
Well, I think the problem goes back to the initial conversation that carried on long after the announcement of no prosecution was made, and it's also a problem to be found in any statement that would put him in a position of being, in some sense, in his mind at least, duty-bound to announce when a shred of evidence or a piece of evidence or a laptop with unknown material on it comes in that they want to look at. It's not within the power of the prosecutors in this country to hold forth publicly about bad information they've learned about people when they're not ready to file a prosecution. If you imagine what...
I totally hear what you're saying, and I don't want to run out of time, and I agree with your point, but since he did it that way the first time around, didn't he need to, I mean, given maybe that was a mistake, but he already did it. So in some sense, he had to come out and correct the record, since that's the way he handled it the first time around.
I heard some of, but not all of his testimony, and at least the first couple of times he answered the question, he said that he couldn't say for sure whether he would reopen an investigation, and that you'd have to, if he got new information, that he'd have to look at it to try to figure it out. Now, if in fact he said, and you may be right, I'm not contradicting you, but if in fact he said to Congress that he would tell them if he got any more information, whatever its significance, whether it had nothing, then he made a mistake. He never should have said that. He should have said, as a prosecutor, we're not allowed to issue public reports on the state of our investigations. The net result of it here, if you put yourself in the position of a citizen who's not running for president, and you imagine that there's going to be a running commentary on an investigation when the government doesn't have the goods to file a case against you, you can imagine what a tremendous abuse of government power that is. And here, it's not just the unfairness to the subject of the investigation, to Hillary Clinton, it's unfair to the whole country, because what we've now got is a complete case of uncertainty about what are the facts and what consequence should they be given, and nobody knows. And that's why these things are not made public. That's why transparency in the status of an investigation is wrong.
Donald, thank you. I wish we had more time. Thanks for coming on. Interesting stuff.